Definition by J. G. Stark. The material sources of international law may be defined as the actual materials from which an international lawyer determines the rule applicable to a given situation. Sources. Legal reference for sources of international law is the Article 38 of the Statute of International Court of Justice. These are as follows. 1. International conventions, whether general or particular, establishing rules expressly recognized by the contesting states. 2. International custom, as evidence of a general practice accepted as law. 3. The general principles of law recognized by civilized nations. 4. Subject to the provisions of Article 59, judicial decisions and the teachings of the most highly qualified publicists of the various nations, as subsidiary means for the determination of rules of law. So the sources of international law are basically 6. Customs. Treaties. General principles of law. Juristic works. Decisions of organs of international organizations, and decisions of international tribunals. The first source of international law is international customs. Customary rules of international law are the rules which have evolved after a long historical process culminating in their recognition by the international community. There is a difference between usage and customs. Usage represents the twilight stage of custom, while custom begins where usage ends. Usages may be conflicting, whereas customs must be unified and self-consistent. Usages develop into customs in 4 ways. 1. Diplomatic relations between states, for example, acts, declarations, official statements. 2. Practices of international organs, for example, advisory opinions. 3. State laws, decisions of state courts, for example, the Scotia case. 4. Provisions in treaty, for example, North Sea Continental Shelf case. Elements of international customs. 1. Long duration. Long duration is unnecessary. Duration is particularly true in municipal customary law, but not in international customs. Article 38 of ICJ directs to consider international custom as evidence of general practice accepted as law. International customs have been generated in short duration, for example, customs relating to sovereignty over airspace and continental shelf. 2. Uniformity and consistency. Complete uniformity is not necessary, but it must be substantial. In asylum case, it was held that the rule invoked should be in accordance with a uniform usage practiced by the states in question. 3. Opinio juris sive necessitatis. To qualify as state practice, the acts must be consistent and general international practice, as held in the cssnotes case. Judicial application of customs. Courts, after a detailed investigation of the state laws and practices, treaties, writings of publicists evidencing usage and decisions of courts, find that they uniformly prove the existence of a valid customary rule. For example, the Paquete Habana cssnotes case. Treaties. Article 38 of the Statute of ICJ considers treaties among the first sources of international law. Article 2 of the Vienna Convention on the Law of Treaties, 1969, defines a treaty as: a treaty is an agreement whereby 2 or more states establish or seek to establish a relationship between them governed by international law. Types of treaties. International treaties are of 2 types. 1. Lawmaking treaties, and 2. Treaty contracts. Lawmaking treaties. Lawmaking treaties are a direct source of international law. It developed in the middle of the 19th century as customs were proving to be inadequate. Lawmaking treaties are of 2 types. 1. Treaties enunciating rules of universal international law, for example, the UN Charter. 2. International treaties which lay down general principles, for example, 1958 and 1960 Geneva Conventions on Law of Sea. Treaty contracts. 2 or more states enter into treaty contracts. The provisions of such treaties are binding only on the parties to the treaty. These treaties help to form international law through the operation of the principles governing the development of customary rules. General principles of law. General principles of law are those principles which have been recognized by almost all the states. This source helps international law to adapt itself to the changing times and circumstances. Examples. Pacta sunt servanda, agreements must be kept. Residential judicata, a matter already decided, cannot be adjudicated upon. Audi alteram partem, let the other side be heard as well. Case studies. In the Haja Factory indemnity case, the PCIJ applied residential judicata. In Mavromatis Palestine concessions case, the court applied the general principle of subrogation. Decisions of international tribunals. The decisions of international judicial, state judicial and international arbitral tribunals are a source of international law. International judicial decisions include the judicial decisions of the International Court of Justice, ICJ, the successor of the Permanent Court of International Justice. These decisions are not binding on the parties. Article 59, Statute of ICJ. ICJ does not follow the doctrine of precedent, which means its earlier decisions are not binding on the court itself and the court is free to deviate from its earlier decisions. State judicial decisions. State judicial decisions become rules of international law in two ways. First, state judicial decisions are treated as weighty precedents and binding authorities. Second, the decision of state courts may become the customary rule of international law in the same way as customs are developed. Decisions of international arbitral tribunals. Decisions of international arbitral tribunals such as the Permanent Court of Arbitration, the British-American Mixed Claims Tribunal and others, have contributed to the development of international law. In the following branches, arbitral decision has either added to or clarified the law: territorial sovereignty, neutrality, state jurisdiction, state servitudes and state responsibility. Decisions of international arbitral tribunals. Here are some notable arbitrations regarded as landmarks in the history of international law. The Alabama Claims Arbitration, 1872. The Bering Sea Fisheries Arbitration, 1893. The Pious Fund Case, 1902. The North Atlantic Fisheries Case, 1910. Juristic Works. According to Article 38 of the ICJ, the works of highly qualified jurists are subsidiary means for the determination of the rules of international law. Juristic works are not an independent source of law, although they do lead to the formation of international law. Decisions of the organs of international organizations. According to Stark, decisions of the organs of international institutions may lead to the formation of rules of international law in the following ways. 1. In institutional matters, for example, it was ruled by UNSC that the absence of any member will not be considered a veto. Hence, the development of a custom. 2. Resolutions may be binding concerning internal matters of institutions. 3. Organs of institutions can decide the limits of their competence. 4. Interpretation of their constitutional instruments, which may become a point of international law. 5. Some international institutions are empowered to give quasi-judicial decisions. For example, the opinions of the jurists of the European Economic Community may help in the development of the customary rule of international law. 6. An organ may refer a matter to an international committee of jurists for investigation of a legal problem. Besides these sources, the other subsidiary sources of international law are international comity, state paper, state guidance for their officers and reason.